Hi, good afternoon, everybody. I'm Rick Hasen of the UCLA School of Law and the Safeguarding Democracy Project. Welcome to the final of our webinars for the 2025-2026 academic year. I do want to tell you about one upcoming event over the summer. On Tuesday, July 7th at 7:30 p.m., we will be holding a Supreme Court term and review event with the UCLA Hammer Museum, and our um, speakers will be Carrie Franklin of UCLA, Justin Levitt of Loyola Law School, Eugene Volokh of Stanford, and Kimberly West Falcone of Loyola Law School. That event is live only, but video of the event will later be posted. All of our events are recorded and shared on the Safeguarding Democracy Project website, which is safeguardingdemocracyproject.org. If you are seeking MCLE credit for today's event, the information will be put in the chat by Ben. And let me thank Ben Austin DeCampo and Harley Ham for their important logistical support, not only today, but for the entire semester. So we've been focusing our webinars on some pretty discrete topics, from risk limiting audits to the role of state courts. And today I thought we would end our series for the academic year by focusing on a bigger question: the state of American democracy in 2026. And I couldn't think of a better panel to join us today to kind of put everything we're seeing in the current political system into some perspective as our panelists today. Let me introduce them. Michael Kang is the class of 1940 professor of law at Northwestern. He's a nationally recognized expert in campaign finance, voting rights, redistricting, judicial elections, and corporate governance. He's co-author with Joanna Shepard of Free to Judge: The Power of Campaign Money in Judicial Elections. He's got a much longer bio, which will be shared in the chat. Lisa Manheim is the Charles I. Stone Professor of Law at the University of Washington School of Law. She writes in the area of constitutional law, election law, and presidential powers. Professor Manheim's scholarship explores questions of federalism and institutionalism. She's been published in leading law reviews, and she is co-reporter on the Restatement of Law Election Litigation, a project of the American Law Institute. And Franita Tolson is Dean and Carl Mason Franklin Chair in Law at the University of Southern California Gould School of Law. Her scholarship focuses on election law, constitutional law, legal history, and employment discrimination. The most important thing I'll say is her forthcoming book is In Congress We Trust: Enforcing Voting Rights from the Founding to the Jim Crow Era. It will be published soon by Cambridge University Press. Thank you all for joining today. And I've asked each panelist to speak for about 10 minutes on any topic related to the broad question: what is the state of American democracy in 2026? So we'll start with Lisa, then go to Franita, and then Michael, and then I'll have questions. And if you have questions in the audience, you can put them in the Q&A box, and I will try to ask some of those questions to our panelists near the end of the program. And with that, let me turn it over to Lisa.
Thank you so much, and thank you for organizing this discussion. I'm really looking forward to it. So I was hoping to speak for a bit about the crisis of legitimacy that the courts are facing, in particular when it comes to the election law space, although it extends beyond that. And at the outset, there are many data points that support the idea that the courts are having trouble with legitimacy. If we look at efforts to try to measure this among the public from Pew or Gallup, what we'll find is that favorable views, for example, of the Supreme Court are near historic lows. And there's also been, with respect to the judiciary more broadly, sort of sharp declines that are more dramatic than what we've seen before with these efforts at recording them. And this sort of problem with legitimacy is always problematic for a court, and it's particularly problematic in the election law space. Election law litigation, it tends to be high profile, high stakes, fast moving, and of course it's just drenched in politics. On top of this, to add to the challenge, what we've seen in recent decades is a real uptick in the use of the courts to try to resolve election-related disputes. So again, these sorts of cases are going to be hard for any court to handle, and they're going to be particularly difficult for a court that's struggling to some extent with legitimacy in the public eye and beyond. So what are some of the causes for this crisis in legitimacy? This is going to be a complicated question with a complicated answer, but I would say that some of the explanations are, in a sense, internal to the courts. Some are external to the courts, and some I think of as reflecting more systemic, broad issues and phenomena. When it comes to the causes for this crisis of legitimacy that are more internal to the courts, what we see is that courts are issuing politicized opinions, or to be a little bit more precise, in that they're issuing decisions that at least appear to be politicized, rather than more sort of carefully following what we might think of as rule of law principles. And when it comes to this initial observation of mine, I'm really focused primarily on the US Supreme Court here. And which is, of course, the most high-profile court that we have. Here, a few trends to note. First, the U.S. Supreme Court's reliance on the so-called interim docket, or the shadow docket, is problematic from a rule of law perspective, in part because the decisions are not issued with the normal procedures. They're not given there's not explanations attached to them in the way there usually are. And we've seen reliance on this system, this docket system, including in election law cases in a way that's problematic. Another thing to flag here is the development of doctrines such as the so-called Purcell doctrine, which essentially tells courts that even if relief is appropriate, the courts should not grant that relief if it's coming too close to an election. This is a principle that makes a lot of sense so long as it's treated in a really careful way, a careful and politically neutral way. But unfortunately, we just haven't seen that level of care, at least explicitly included in, for example, the Supreme Court's opinions. And then as a final note, what we're also seeing is some degree of politicized sort of speech making and commenting by, for example, Supreme Court justices to public fora. And this is also going to be problematic in terms of sort of the legitimacy of the courts. In terms of some of the external factors, the courts have become a focal point for political pressure. And on this note, from the president on down, there have been these pointed criticisms aimed toward not just the court's decisions, but aimed sometimes toward the judges themselves. And often sometimes at least, these attacks can be very personal. Now, as a legal matter, these judges generally have, legal protection against just political pressure, particularly federal judges. But the judges are worried, and they're worried not just in terms of the professional ramifications of being the center of this attention, but also about their own personal safety. And this sort of external pressure, unsurprisingly, is really straining the courts. Finally, in terms of some of the sort of systemic or the really broad phenomena that are affecting the courts, what we've seen is that the public faith or trust in institutions and in the government that has corroded in recent years and decades. And again, it's not just sort of an intuition. To the extent this is, people have tried to measure this, for example, Pew or Gallup, this is in fact what we're seeing. There's, of course, many reasons for this decline in public faith in institutions and in the government. And I won't try to sort of recount all the different explanations we might have here. I will just note that Rick Pildes has written about sort of the value in effective government. I'll restate that. When the government is effective, that's a value. And when it's not able to be effective, that's a problem. And that may help to contribute to the sort of decline in trust in institutions. Either way, courts are part of these governments, courts are part of these institutions, and so they're getting some of the effect of that. Okay, so the story that I'm trying to paint here quickly is a story of where first, simply as a matter of legitimacy, before we get to the merits of any given case, courts are facing a lot of challenges. And second, the causes for this crisis in legitimacy, it's complicated and it's multifaceted. And just to sort of say something that maybe is obvious, it's important for courts to have legitimacy. It's really hard for them to do their work if they don't have legitimacy. They, of course, don't have an enforcement arm. They don't have the power of the purse. And perhaps not unrelatedly, we are seeing resistance, for example, from the federal government to some extent to judicial decisions that are coming out. So what to do? I don't have the answers to that, of course, at least not comprehensively. But in terms of a few ideas that relate specifically to election law, there are a few things that I think the courts can do here. So first, when the courts are being asked to resolve election-related disputes, they should try to do so early. And by that, I mean before the effects of their decisions on an election's outcome are predetermined. So that's one thing. Try to decide cases early when possible before the election results have come in. Another is to be aware of this phenomenon that I alluded to earlier, which is that if you decide a court case right before an election, it's going to have disruptive effects on the one hand to the election process, and it also is going to possibly sort of be a problem with respect to, again, this legitimacy of the courts, because it feels like the courts are affecting the election directly. So again, where possible, try to kind of hit a sweet spot of deciding the cases early, and then also doing so before it's going to be disruptive to a specific election. A third sort of idea that courts might think about is to let the state courts take the lead where possible under law to decide a lot of these cases. Often legal principles would sort of require or encourage federal courts to do that anyway. It is also the case that if we look at the legitimacy of the various courts, the state courts tend to have more legitimacy in the public eye than the federal courts do. And I think the last thing I would flag here is that courts, and again, here I'm really talking about the Supreme Court, US Supreme Court, should try to be a bit more disciplined in the decision-making process, the way the opinions are coming out, how thoroughly they're explaining their opinions, and then also with respect to the sorts of public statements they are making. So I could go on, there's lots of things to say about this, but I am very interested in hearing what the others have to say.
Thank you so much. I do have some follow-up questions, but I'm going to hold them until we get to Franita and then to Michael. So Franita, over to you.
All right. Thank you so much, Rick. Thanks for the invitation. Always a pleasure to be here with you, Michael and Lisa. So I tried to take the prompt seriously because I think, the state of American democracy, the inclination is to be like, well, it's bad. Right. But so I don't want to be alarmist. That's not the point of my presentation today, but I'm gonna say something, but hear me out, right? So it might sound hyperbolic to say that the state of American democracy in 2026 is 1890s Mississippi, but let me explain, right? Like the last decades of the 20th century in the former Confederacy were violent, yes, but that's not really the parallel I'm talking about for purposes of our conversation today. In the 1890s, across the American South, you really had this really remarkable thing happen if you think about it. So during the 1890s, state constitutional conventions rewrote the rules of democracy. So they imposed literacy tests, they imposed poll taxes, understanding clauses, and complex registration systems, which were devices that were primarily designed to strip Black people of their voting rights. So by 1908, every state in the former Confederacy basically changed their state constitutions in order to adopt these facially race-neutral laws to disenfranchise Black people, and it lasted for decades. I mean, really generations, if you think about it. But what's most striking is not simply the disenfranchisement or how well it worked. It's really how it was justified. The architects of these regimes insisted that they were acting within constitutional constraints. So they disclaimed any violation of the 14th or 15th Amendments. They avoided explicit racial classifications. The texts of these state constitutions really were crafted in the language of like neutrality, of reform, of legality. And they could do so because of a gap in constitutional law at the time. So the fact that the Supreme Court of the 1890s didn't really have a legally cognizable conception of racially discriminatory intent. So as long as a law was facially neutral, its purpose, no matter how clear the context, no matter how discriminatory statements were made, in the context of adopting the text, if the law was facially neutral, it was considered beyond judicial reach. So the result was a system in which constitutional constraints could be evaded, not necessarily by defying the law, but by manipulating its form. So, for example, the 1890 Mississippi Constitution disenfranchised any person convicted of murder, rape, bribery, theft, obtaining money and goods under false pretense, and a few other crimes. This provision, which ironically enough remains in effect today, was a cornerstone of the effort to disenfranchise Black voters. As the Fifth Circuit Court of Appeals recognized in the 2022 case of Harness versus Watson, Section 241 was reconfigured in the 1890 Constitution to eliminate voter disenfranchisement for crimes thought to be white crimes, and by adding crimes thought to be Black crimes. The court also conceded that had the law never been amended, it would be a clear violation of the Equal Protection Clause of the 14th Amendment. The Fifth Circuit's recognition that the 1890 Convention was, quote, motivated by a desire to discriminate against Blacks, end quote, was the only concession that the court actually made, though in acknowledging the discriminatory origins of the state's felon disenfranchisement law. Instead, the court found that because Section 241 had been amended twice, in 1950 and then again in 1968, the deliberative process surrounding amended Section 241 was actually sufficient to break the inference of discriminatory intent that would otherwise establish a 14th Amendment violation. The deliberative process that the court sort of heralded as a sign of race-neutral decision-making resulted in additional felonies being added to the list of disenfranchising crimes with each subsequent amendment. So as it stands, nearly 16% of Black voters in Mississippi are disenfranchised because of Section 241. The Harness Court's view that the discriminatory taint of the original Constitution can be cleansed through the amendment process actually ignores that Section 241 was part of an ongoing and systemic effort to create and then maintain an all-white electorate in the state through legal discrimination. The judicial head-in-sand approach embraced by the Harness Court had its origins actually in U.S. Supreme Court case law from the 1890s and the 2010s. In the 1898 case of Williams versus Mississippi, the Supreme Court found that the Mississippi Constitution did not violate the federal Constitution, despite the fact that, as the Fifth Circuit acknowledged in 2022, that the state constitution was adopted in a process steeped in racism. Even though discriminatory implementation of the state's voting laws meant that the defendant in Williams was indicted by an all-white, all-male grand jury selected from the state's predominantly white voting rolls, the facially race-neutral language of the state constitution meant that there was no 14th Amendment violation. Similarly, the Supreme Court, in the 2018 case of Abbott versus Perez, upheld a redistricting plan that diluted minority votes on the grounds that the prior legislature's discriminatory intent does not carry over to a subsequent legislature. This meant that a redistricting plan adopted with discriminatory intent could effectively be cleansed of this taint by being reauthorized by a subsequent legislature. So we have effectively moved back into a world in which the court operates as if there's no legally actionable concept of discriminatory intent. So that brings us to the present. Supreme Court is hearing a case called Calais versus Louisiana, and the court in that case has to resolve a dispute over redistricting and really the proper role of race in drawing maps under the Voting Rights Act. The case arises from a court-ordered redistricting plan in which Louisiana had to draw 2 majority-minority districts instead of the one that existed in the prior plan in order to comply with Section 2 of the Voting Rights Act. Instead of adopting a plan that had 2 majority Black districts that were fairly compact, which was possible, the legislature adopted a plan with an oddly shaped majority-minority district that was almost certain to raise constitutional concerns under the court's current jurisprudence. In addition, legislators made inflammatory statements also designed to raise judicial eyebrows. So saying things like the odd shape of the district was to comply with the court order, that the district court order resulted in the construction of a district based primarily on racial considerations and so on. So for Supreme Court watchers, the term primarily considered race should clue you in just on what the legislators were trying to do, right? They have figured out just what they need to say in order to make a redistricting plan susceptible to invalidation. The legislature, who had a preference for the prior plan invalidated by the district court, despite its deleterious effects on Black political power, intentionally enacted a plan that they knew would not pass judicial scrutiny. Surprising no one, the state is not defending this map before the Supreme Court. Now, this is a familiar move, right? Like the architects of the 1890s regimes, today's challengers operate within the vocabulary of constitutional law. They don't reject the Constitution, instead they invoke it, right? They emphasize race neutrality, equal protection, the dangers of racial classification, but in doing so, they really do exploit the very frameworks designed to enforce constitutional guarantees. Then, as now, the danger lies in formalism detached from reality. In the 1890s, facial neutrality masked a regime of exclusion. Today, an overemphasis on the formal use of race risks obscuring the underlying purpose of the Voting Rights Act, which is to ensure that minority voters have an equal opportunity to participate in the political process. Now, of course, I'm not saying, to reiterate, that the parallels between now and the 1890s are perfect, right? History never repeats itself so neatly, but the pattern is recognizable. When courts focus too narrowly on form, on whether race is explicitly invoked, rather than why it is being invoked, they create space for constitutional values to be undermined in practice. They invite actors to game the system, to comply with the letter of the law while violating its spirit. You end up with a discriminatory state practice that is technically legal, but clearly unconstitutional. And this has very real consequences for everyday voters, right? In the 1890s, the result was a near total exclusion of Black voters from the electorate. This shaped American democracy, entrenching one-party rule and silencing dissenters for generations. While the stakes today are different, but they are no less significant. That issue is whether the Constitution will be interpreted in a way that recognizes the realities of discrimination, or whether it will be once again permitted to sort of ignore those realities in order to be just in order for courts to just focus on formal compliance. Okay, so I'll stop there.
Thank you. And I'm hoping Michael's going to come in to cheer us up with some better news about the state of American democracy in 2026. Over to you.
I smiled.
I'm sorry to disappoint you, Rick. Thanks to Rick and Ben and Franita, Lisa, everyone here for making this event possible. It's great to see everyone, if only virtually. So I thought what I would do is take kind of a bird's eye view of democracy, American democracy, rather than something that's more election law specific, and talk about the surprising tenuousness of First Amendment rights. And I say surprising because I think before this second Trump term, we were, generally largely comfortable with the idea that constitutional rights like First Amendment rights would generally be honored by the federal government without being forced by courts to honor them, and that the federal government generally would respect the rule of law and not maximize its use of formal authority to coerce private actors to do what it wanted. I think the Trump administration right now is pressing its legal authority up against First Amendment rights more aggressively than any other presidential administration in my lifetime. But I think we should understand what's happened over the last couple of years, not only as an extraordinary use of executive power by Trump, but also as exposure, I think, of a basic vulnerability of constitutional rights in the post-Cold War age of hyper-partisanship, and therefore a kind of basic vulnerability of American democracy. So what I want to do is just kind of quickly run through, three different examples of what the Trump administration has done. I think the facts are largely familiar to probably this audience, but law firms, universities, media companies, the Trump administration has ordered suspension of security clearances, restricted access to federal buildings for law firms that committed various offenses in the Trump administration's view, including representing clients in litigation against the administration or the Trump campaign, or engaging in various DEI practices. This includes a huge number of firms, some of which have fought the administration: Perkins Coie, Elias Law Group, Jenner & Block, WilmerHale, but also a bunch of firms, Paul Weiss, Skadden, Kirkland & Ellis, very well-known, very successful law firms who have settled with the federal government. And I think that's important, promising, among other things, to provide millions in pro bono work for causes that Trump supports. Now, it's pretty clear here the law is on the law firm's side when it comes to the First Amendment. The firms that have litigated the Trump administration's targeting of them have won in court on First Amendment and other grounds. One district court ruled in enjoining the administration that the campaign against the law firms was doubly violative of the Constitution because retaliating against firms for the views embodied in their legal work violates the First Amendment. Central command, the government may not use the power of the state to punish or suppress disfavored expression. Seems like for the moment, the Trump administration has stopped this campaign for the moment, at least. But I think importantly, most firms really settled rather than litigate this to the end. Along the same lines, the Trump administration's filed a bunch of lawsuits, unilaterally cut federal funding for dozens of universities, including Northwestern, my own, for alleged violations, a whole range of things, a lot of which have to do with Title VI and inadequate responses to anti-Semitism on campus and engaging in various DEI practices. This includes basically the entire Ivy League, the UC system, again, Northwestern, among many others. This has forced, at least in part, the presidents of a number of the challenged universities to resign. Mike Schill here at Northwestern, Jim Ryan at Virginia. Linda McMahon, the Secretary of Education, explained at the time that what they were doing, or kind of their motivations, universities should be able to do research as long as they're abiding by the laws and are in sync with the administration and what the administration is trying to accomplish. Harvard, kind of very prominently, has refused to settle. They face 13 separate investigations by at least 10 different federal agencies so far. Harvard's won in court, again, so far, where a federal district court concluded that the administration used anti-Semitism as a smokescreen for a targeted, ideologically motivated assault. Brown, Cornell, Northwestern, Virginia, Penn, and Columbia, there may be others, have settled by paying millions in penalties to the federal government and submitting to various levels of oversight and other limitations on DEI policies in particular. And then media companies. Here, I'm not sure how much detail is really necessary, but the Trump himself has sued 60 Minutes Paramount, the Des Moines Register and Gannett, ABC News for various things that he claims those news outlets have misstated. FCC Chair Brendan Carr has opened investigations on each of the major networks besides Fox for their coverage of 2024, the election, including the debates and Saturday Night Live. Kind of famously, ABC initially suspended Jimmy Kimmel after he criticized Trump, and Carr had warned earlier that day, we can do this the easy way or the hard way. Disney settled, paying $16 million. CBS has agreed to pay Trump $36 million to settle these suits that I think every First Amendment expert that I've talked to didn't think there was much to Trump's case here, but nonetheless, it was easier for them to settle and make it go away and submit to the administration rather than fight this in court. The point here is along all these lines, not whether the Trump administration is justified or not justified politically about what it's doing. I'm not really interested in sort of debating the goals, the political goals that Trump administration has underlying some of this. The point is that the Trump administration is using the federal government's power to exert this kind of enormous leverage over private actors, where it's fairly clear that the claims that it's making are not meritorious. This is what I think of as bad faith government. That the government is doing this because it can. Not because it's pursuing kind of federal policy in good faith, but instead it wants to punish its enemies, help its allies, and force its opponents to acquiesce to what the administration wants politically, regardless of the underlying merits of the claim. And so I think here, the legal rights that we're talking about, First Amendment rights, that they're enforceable in court, clearly. That's important, but it's actually a lot less helpful than we might have assumed. If the pressure of the federal government is enough that actually going to court is too slow, too reactive, too expensive to help you out. The workability of these rights that we've really largely defined during the 20th century have depended really important part on good faith government, for the government not to take advantage of its enormous leverage. And the Trump administration is no longer refraining from doing that. Talking to people at Northwestern, one person I talked to said, in these lawsuits, people tell institutions like Northwestern, you should fight this. The law's on your side. But someone I talked to said, ultimately you're alone. No one's going to help you. And ultimately, it's much easier to settle and give in than fight this at enormous cost and stress, especially these various institutions that I've sort of outlined. And so what this means, I think, for democracy is that the Trump administration's used this kind of vulnerability of First Amendment rights to tilt the terms of democratic contestation toward their favor by using the federal government's power in ways that previous administrations just had not. It's intimidated and undermined its opponents while empowering its allies. I think, importantly, if we think about why this happened and why it might go beyond Trump, like many things Trump, I think bad faith government is partly because of Trump, but it's not entirely just because of Trump. It's really abetted by the modern political conditions of hyperpartisanship and exposes the fact that we had a different sort of politics during the Cold War, where nonpartisanship was a norm. And we believed in things like a nonpartisan press, nonpartisan election administration, vibrant civil society, constitutional rights respected by both sides. And I think right now, a lot of those norms have eroded. A lot of the Cold War consensus about nonpartisanship, both in the characterization of institutions as nonpartisan and a belief in the possibility and value of nonpartisanship, has kind of crumbled in the post-Cold War era. And we're sort of enveloped in this hyper-partisan world where there's increasingly suspicion of any characterization of anything as politically neutral. And the Trump administration's approach to politics as a kind of total war is increasingly commonplace, really on both sides of the aisle. So I'm not worried that we won't have elections. That's not really the concern exactly, but that the healthy conditions for a competitive and fair elections within the democratic process, as we've normally conceived them, have kind of eroded for the longer term and not just for the Trump presidency. So I'll stop there. Thanks.
Well, you were right that you didn't cheer me up, so thank you for
Yeah.
those remarks. I have a question I'll direct to each of you, and then if the others want to chime in, and then I want to have a more general discussion. So first, let me come back to Lisa. Um, there's been a lot of talk about the shadow docket, especially this week with some leaked documents that went to the New York Times related to the kind of the use of the shadow docket in relation to a major executive program under the Obama administration. Certainly, there are election emergencies that are going to have to be resolved by the Supreme Court. And I'm wondering what you think would make for better practice. So I want to kind of focus on solutions here. What could the Supreme Court be doing? It's not always going to be able to defer to state courts. A lot of these cases are coming from federal courts, and that someone's got to be the last decider. What is it that the Supreme Court could be doing in relation to those emergency cases that it's not? How could things improve?
Yeah, thank you. And you're correct to observe that part of the struggle when it comes to any of these cases, but in particular when it comes to election law cases, is that we do have time pressure sometimes, and that's just irreducible. So I think there are at least sort of two things that the court could do in response to these sorts of pressures. The first is to really force itself to articulate the grounds for its decision. And if it feels like it cannot do that at the time, in the time that it has allocated, which is a fair concern. I mean, we don't want majority opinions out there that aren't well reasoned. The court could issue a judgment, issue an opinion, and then take some time and then explain itself a couple months later, if that's what it needs to do. And if the court were to do that, I think that would help with some of the concerns that this feels like it's not consistent across cases. It's hard for lower courts to know what to do with these decisions going forward, and so on. So I think that would be one answer, would be to just provide more of an explanation and to do it at the time if they can, and if they can't, then at least to do it later. The second is, I think, a bigger suggestion, which is the following. The Supreme Court is not well designed as an institution to micromanage the lower courts. There's 9 justices on the US Supreme Court. They all vote together. They are reliant on briefing that takes time to put together. They aren't doing their own fact-finding, et cetera. And so rather than just sort of accepting that reality and limiting what they are doing with the lower courts, what the Supreme Court seems to have done is it's switched over to this model where it is willing to forego procedure, the normal procedures it has. It's willing to kind of compromise its own decision making in order to more effectively manage the lower courts. And I think what I would say in response to that is I'm not sure that was the right call by the US Supreme Court. I think there is a virtue in allowing the lower courts to have a bit more freedom and sort of to defer more to the lower courts in a sense than the Supreme Court is doing. So I think I would say in response to your point that there has to be some court that has the last word. Maybe when it comes to preliminary relief with respect to an upcoming election, sometimes the last word should be a district court or it should be a court of appeals. And that would help to, I think, respond to some of these issues.
Thank you. I don't know if either Michael or Franita want to weigh in on that before I turn to another question. No. Okay, so let me come to you, Franita, and I want to ask you, again, I'm trying to be constructive here. I want to ask you about the world post-Calais. So you mentioned we might be seeing the Supreme Court either strike down Section 2 of the Voting Rights Act as unconstitutional or hobble it so that it's no longer effective. And you mentioned how hard it is to bring intentional discrimination cases. And I'm wondering if that might be a path to try to push further on that if, as some predict, we're going to see some states, especially in the South, engage in redistricting in order to break up some of these minority opportunity districts that the states had to draw under Section 2. So is there maybe a path under the Constitution to try to get to what we're going to potentially lose in Calais?
I think so. So there's always a path in the sense that you can imagine a case where a litigant is able to create a compelling narrative about whether or not the legislature acted with intentional discrimination, right? And there are some cases where that has been able to be established. But I also want to make one related point before we talk about the intentional discrimination as a path forward. It's not that Section 2 was all that successful leading up to this point, right? Like we don't have like a ton of successful Section 2 cases. In the last 40 years, Section 2, the cases they're really expensive. They take a long time. If you get a Republican administration, they're not really enforcing Section 2. So I think in some ways, like I don't want to make it seem like Calais happens and then all of a sudden we are in this bad spot. We've actually been in this bad spot for a while. And it's also true that even with the possibility of bringing an intentional discrimination claim, courts have not been amenable, right? So it's like, yeah, you can try to figure out a path. And maybe this goes to an evidentiary question of what kind of record do you need to build in order to convince the court that intentional discrimination exists. But I think overall, the path forward in all of this has been fraught for a while when it comes to the courts. And so instead, I think we have to push back on this idea. And it actually ties into something Lisa said about the courts being the last decider. They don't always have to be the last decider. The reason I didn't make this point in my presentation is because it sounds stupid, but it is true, right? It is true that Congress can weigh in on some of this, right? And maybe this goes to Michael's point about good government versus bad government, right? In some ways, Congress has been a bad actor here in abdicating some of its responsibilities of oversight with respect to the Trump administration. So the idea of Congress coming in and being the last decider on some of these questions of elections sounds a little bit ridiculous, unless we think about Congress being actively harmful as they would be if they passed the SAVE Act, right? But in theory, our system is one where the court doesn't necessarily have to be the final decider here, right? Congress does have some space here to act outside of like election emergencies, right? Where Congress can do some things where we don't always have to turn to the court and say, okay, is there a path forward when the court has been actively narrowing the path for decades?
Thank you. And you anticipated the question I was going to ask to Michael, which is about the role of other actors. So we've heard bad things about the role of the courts in protecting democracy, about the executive branch. So that leaves, I think, three possibilities. More from Congress, as Franita suggested, more from states and states pushing back, and more from civil society, which you mentioned has been somewhat eroded, but I think there has been somewhat of increased attention to finding common ground to promote democracy. So I'm wondering if you could kind of like a comparative institutional answer, like what is the path forward in the face of problems with the courts and the executive?
Yeah, I mean, I think one of the problems we've seen is we have certain sorts of vestiges of Cold War politics in terms of the way that parties work and the way some of these institutions function, but they're operating and how law operates within a different context. And probably what needs to happen to correct what I see as certain pathologies as institutions, as you're sort of suggesting, have to adjust to. Civil society has to adjust and resist this in ways that we never thought was necessary before. I think one of the things that's helped the Trump administration achieve what it's doing, it's I think been incredibly effective in doing what it's wanted with a very ambitious agenda. It hasn't been successful across the across the board, but I think it's been much more comprehensive than certainly I expected, in 2024. And part of that is there's been basically, until very recently, very little resistance from within the Republican Party. And so when we think about nationalizing politics, and that's happened as part of hyper partisanship for a while, is, you used to think in terms of Congress having a different set of interests and institutional prerogatives than the executive, and states having a different set of interests and prerogatives than the federal government, and these different players kind of protecting those their institutional turf. A lot of that has gone away kind of in the modern era. So the Republican Party sort of acts, if not entirely monolithically, but certainly generally on the same page. And that lack of resistance from within the Republican Party has really helped Trump. I mean, right now, it seems like until very recently, and things may change, and this is an important part of the story, but until recently, the Republican Party has generally treated what Trump wants as its agenda. And that lack of internal resistance turns whatever he wants to do into a partisan dispute in which partisans automatically line up on one side or the other without really sort of challenging what's going on internally. Now that may change. So I think one of the important things that we see is when things seem to be going reasonably well from a partisan perspective, the parties kind of line up. It's certainly the Republican Party kind of lines up behind Trump. Some of that may be Trump specific. Some of that may change if they get destroyed in the fall elections. So I think right now, the institutional question kind of hinges on the degree to which people within the Republican Party really fear Trump. And we'll see how much that changes if the elections don't go well for them. Institutional control switches party hands, and Trump is exiting the scene. We'll see how much of that's durable and how much of it depended on a certain set of circumstances. But I fear that the larger story means that Trump has kind of opened the door and shown a way for some of these practices to continue beyond just the next 2 years. And so that's my worry. Civil society also, I didn't really address that. It has been reasonably effective, for instance, in resisting ICE. I think it's been real. We've seen that here, not far from where I live. Civil society kind of responding to those threats, and I think that's a real adjustment that regular people and political organizations and nonprofits have had to make and perform in ways that they've never had to. So I do think that there are effective responses from civil society as well, but I do think the Trump administration is working really hard to kind of undercut the ability of civil society to respond in those kinds of ways as well.
Okay, well, I think it's interesting that I've got a panel here of election law experts, and none of you talked very much about the mechanics of the upcoming election and whether we can feel comfortable that people will be able to vote fairly in 2026. And I'm wondering, I did tell you to go broad, and that's more of a technical question. I'm wondering how confident you each are, because this is the question I get the most, and it's stuff we've talked about on other webinars, how comfortable you are that we're going to be able to hold a free and fair midterm election in 26. And so I'd like to hear from each of you, or any of you who'd like to respond to what you're looking at and what you're thinking right now.
I guess I can start because I've actually given some thought to that question in the sense of part of my concern, I guess, about the current moment is how quickly we backslid, like to these attempts to disenfranchise people really on a national level in some ways, right? The danger of the SAVE Act, right? The SAVE Act would be a documentary proof of citizenship requirement for federal elections. And it would harm a lot of voters who don't have the requisite documentation. But it's also one of the first times that Congress is using its institutional power, if this law passes, to actively disenfranchise people, right? Usually it's Congress sort of pushing back on states that try to disenfranchise people. And so I think part of it is, just this concern that we're living in a different world. But it is also a reminder, and I'm going to go really broad here because I do think that come November, most people will be able to cast a ballot, right? Like I do think we'll be able to have an election. But I think what this highlights is the fact that we always have to stay vigilant, right? Like we can never become complacent and comfortable with the status quo because look how quickly we end up in the bad place when we become complacent and we think that we've made it and we check these boxes. And oh my God, in 2020, north of 100 and however many people voted. And so therefore we've made it because we did that in a pandemic. Everybody's happy. And then all of a sudden in 2026, we're like, will we have free and fair elections in the fall? Look how quickly our language has pivoted, right? So I don't think that I will never again take for granted the fact that we have an obligation to make sure that democracy is actually working.
Lisa?
Yeah, Yeah, so I mean, this is a this is an important question. I think one way I might answer it is to say that if the law generally holds, then I'm confident that we will be able to discern the will of the electorate, and that accordingly we will have successful elections. Now, if the law doesn't hold, if and I should clarify that in any election you're going to have sort of problems. You're going to have the law not followed here or there. You're going to have this ballot counted when it shouldn't have been, et cetera. These sort of minor errors are predictable and routine. What I'm talking about is a more fundamental breakdown in the rule of law. If we have that situation, then the way I think about my own answer is that kind of by design, this is sort of above my pay grade. I'm a law expert, and so if the law is not holding, it's hard for me to know what happens at that point. That being said, in terms of the law holding, there's a few things to note. First is that we have literally centuries of election law that's been developed through time. A lot of the sort of challenges and concerns and potential for subversion and the like that one might worry about, we do have legal mechanisms to respond to those. And to that end, the courts are used to dealing with, for example, fabricated claims. That's not something that's particularly challenging for a court to handle. The second thing I would say is that our elections in the United States, for better or for worse, are decentralized. They're not run by the federal government. And even if you go to an individual state, there's some top-down control, but there's a lot that's being done at a local level. And as a result, it's actually just hard to know exactly how to undermine the election system across the country. It's not obvious sort of how to interfere with these legal mechanisms. And I think the third thing I would say is that based on my understanding, if an election is close, it's much easier in a sense to kind of try to interfere with the outcome in ways that are not necessarily consistent with the rule of law. By contrast, if we have a wave election, the United States has a wave election at some point, it's much harder to find ways of sort of undermining that election outcome. So I think on the whole, I think that the upcoming elections will reveal the will of the electorate and they'll run smoothly. But if we see unprecedented breakdowns in the rule of law, I'll be trying to figure it out, but it's just not something that I'm an expert in a sense.
Michael?
Yeah, I mean, I think one of the things that I sort of understand over the course of my career is the types of problems we're thinking about today are quite different than they were when I started my career. I mean, 20 years ago, we probably wouldn't have had a discussion about the state of democracy. And we would have been talking about much more nuts and bolts kind of doctrine kinds of things rather than thinking kind of bigger picture about the state of democracy. And I think today, I'm much more interested in looking at comparative political science and history to kind of understand what's this new context that we're moving into, because it's not the one that we've had for a really long time. And we're not just kind of tinkering at the margin with rules off of a really broad bipartisan consensus about how things should work. So I think that's part of what's going on is we're really shifting to these kinds of bigger picture questions. I think about whether democracy or whether elections will work as planned in this year, for instance. I think there's at least kind of three different phases you can think of. Like one is how do we determine the rules about elections? And I think that's been super partisan for a long time. And we're seeing that kind of probably taken to another level with kind of the redistricting mid-decade stuff where really there are no rules anymore. And it's just a question of what you can do within the constraints of law that you confront and what you can do politically in terms of timing. So I think that's a kind of free for all, and it is kind of what it is. The second phase is the conduct of elections. So like when people vote, are their votes counted? Are people turned away from the polls? Are they intimidated from going to the polls? And I think right now, actually, that's worked okay. So if we look at 2020 and 2024, the system is kind of held so far there. A lot of that has depended on good faith government, like election workers and judges kind of upholding the law and doing things in a nonpartisan way. And so I think that process hasn't been infected by a lot of what we're talking about, that people really do believe in kind of nonpartisan election administration and kind of faithfully counting votes and following the rules. I think the real question there is, will that change? Because I think that's exactly what we're talking about when we speak to kind of the breakdown of the system. And then there's this kind of final phase, which is not just counting of the votes, but like determining whether the election winner will be recognized as the winner of the election. And obviously that is super contested. We haven't really tested that because in 2024, Trump won. And so had Trump lost, it could have been a totally different story. And we could be dealing with completely different circumstances right now and talking about different problems. So it wasn't tested. It could get tested this year because it'll probably go pretty well for the Democrats. Trump is not going to like that. And I think we'll see a little bit whether Trump's election denialism, which he surely will bring to bear, if things don't go well for him, is resisted by the Republican Party, or there is a kind of unprecedented effort to kind of fight the results. So I think we're up in the air for that reason. And a lot of this depends on decision makers kind of sticking to Cold War norms of nonpartisanship that have so far generally held, but may not as people get replaced and partisanship gets worse.
Well, we don't have that much time left. I want to squeeze in at least one question from one of our viewers, and it has to do with the mid-decade redistricting that we're seeing. I'm going to kind of the question is about what the Virginia Supreme Court's going to do, and I don't know that any of you have any specific knowledge of that, and happy to hear from that. But I want to ask more broadly. We saw Trump encourage an egregious Republican gerrymander in Texas. Democrats responded with an egregious gerrymander in California, which voters approved of. And then Virginia did, I mean, they took a 40+% Republican state and made it a 10-to-1 Democratic delegation if this gets upheld. Is this a good news story or a bad news story? I mean, is this a fight fire with fire? Maybe things will get so bad that we'll have Congress fix partisan gerrymandering, or is this just like a race to the bottom norm erosion? So let me start with you, Michael. Then I'll go to Franita, and we'll end with Lisa.
Well, it's a sad story. I don't think it's a good or a happy, like a good or a bad thing. It's probably on net a bad thing. I'm not sure that I can blame the Democrats for retaliating the way that they have. What they're trying to do is stop the Republicans from taking advantage of gerrymandering to flip a midterm election potentially. And so they're fighting fire with fire. And they've had unusual obstacles because they've adopted redistricting reforms that they've had to kind of peel back to do this. I think probably it makes sense to think about the fairness of districting at the congressional level, at the institutional level, rather than state by state. And so by that measure, this makes sense. And I think it makes sense if it deters, Republicans or future Republicans or future Democrats from going down this road, because you will be counteracted by the other side and it won't pay off. And I think the Republicans are thinking some of that through right now because of the way the Democrats have retaliated.
Franita.
I'm confused by the question, Rick. I think in part, it reminds me of the question that I get every 4 years about the Electoral College, right? Like everybody wants to know if it's bad. And then the question gets really, really intense the years where the Electoral College and the popular vote don't line up, right? Like, oh, it's really bad. We got to get rid of it, right? Like this feels like that to me because partisan gerrymandering has always been bad. It's been bad for like 200 years bad. Right now, everybody's like, oh my God, partisan gerrymandering. I remember Adam Cox, I think it was, wrote an article like 25 years ago where he sort of was trying to gauge, like, how do we tell if partisan gerrymandering is bad? Like, do we look at Congress as a whole? Or maybe that was Nick. I can't remember who wrote this article, but like, it's kind of what we're seeing now, right? This is about offsetting one gerrymander with another gerrymander, right? And it's entirely predictable. And it seems to me that it's a failure, a democratic failure in some ways, the fact that we haven't been able to do anything about it. but I'm also sort of refusing to participate in this conversation like it's a new problem, right? Like this is something that we should have done something about a long time ago. But I have wondered, and then I'll stop. I have wondered if, and I have, this is like a half-baked thought, if on some level, the delay with Calais has to do with whether or not the Voting Rights Act could be a useful tool to rein in some of this gerrymandering now that Democrats are doing it. So I'll stop there.
Lisa, we'll give you the last word.
Yeah, thank you. So, yeah, I think this is a hard question to answer, and you know, this is something that politicians and others have been grappling with for quite a long time, right? So, do you respond to some sort of problematic political move by sort of taking a high road, or do you sort of respond in turn? And I think one way I think about it is that in the short term, I think sort of responding to these sorts of extreme gerrymanders with extreme gerrymanders on the other side, in a sense, in the short term, it's a good thing because it's correcting a certain kind of acute distortion. The trouble is, longer term, all the criticisms of this sort of extreme gerrymandering, like they don't go away just because it's been sort of counteracted in part. And so longer term, this is bad. The sort of districting isn't zero sum between one party and another party. There's questions not only of which members of which party get elected, but also how responsive are they to the electorate, and to which parts of the electorate? How accountable are they? How effective is government, which is something we talked about before, in light of the way people are being elected? And all of that potentially is undermined by these sort of extreme gerrymanders. So I think short term, I understand why this is happening. Longer term, I think this is a problem. And along with so many other things, it could use some sort of correction.
Well, this session raised a lot of things for us to think about as we move towards November and beyond. So I want to thank Michael Kang, Franita Tolson, Lisa Manheim for this discussion. Thank all of you for participating in our webinars over the last 9 months, and we'll see you back with a new set of webinars in August. Take care, everybody. Thank you. Bye-bye.